Okay, so while they're getting mic'd up, I will start making the introductions because it's really my honor to introduce our moderator for the legal panel, Sam Guzik. He's no stranger to crowd finance or Reg A. He's been introduced before. He was on the panel with Gene. But he has been really on the forefront of the whole Reg A movement. He was the one that actually introduced it, the opportunity to me, and opened my eyes to what was happening once the SEC had proposed the new rules for Title IV. And you know, it's been ever since. I mean, Sam and I, we've done a bunch of webinars together with Congressman McHenry and Congressman Schweikert and Dave Wield, and Sam's really been the go-to attorney in that Reg A space. So it is a true honor. And with that, I'm going to hand the mic over to Sam Guzik.
So I'm going to start off by letting the panel introduce themselves briefly. Ladies first, so I'm going to start with Sara Hanks.
I don't know about the ladies. Is the mic on? Can you hear?
There's a,
All right. I'm just going to... Yes, no? Yes.
Yes.
All right.
Yeah.
I don't know about the ladies thing, but I will admit being female. I'm Sara Hanks, CEO of CrowdCheck. We do disclosure and due diligence, compliance work in general for online alternative investments, including all forms of crowdfunding.
Very good. I'm Gerry DiFiore. I'm a partner with Reed Smith. Don't be fooled by my full head of dark hair. I'm 30 plus years a securities lawyer. Started my career at the SEC in Washington, where Sara and I actually met, and I've spent much of my practice dealing with emerging companies in all sorts of markets.
I'm Peter LaVigne, partner at Goodwin Procter in New York City. I head the broker-dealer group, which is part of the financial institutions group. And for a while now, our financial institutions group has been working with our very active technology practice in what we call a fintech incubator, helping small technology companies that want to do banking, brokerage, they want to run exchanges, they want to do swaps. We help them with all of the usual startup things, and then in addition, we provide advice about financial regulatory issues.
My name is Doug Ellenoff. I'm a partner at the law firm of Ellenoff, Grossman and Scholl, and we specialize in crowdfunding. And today I can also say proudly that I am co-founder of iDisclose with Georgia Quinn, whose presentation you got to hear earlier.
thank you. Yeah, we're going to get into discussion of some new regulatory alternatives for offerings courtesy of the Jobs Act. And I just want to say, sitting and listening to this room today, there are certain themes that reverberate. One is there are certain constants here. Raising money is not easy. Finding investors is not easy. And matching investors to the deal is really the challenge. Secondly, there's always the issue of not only deal flow, but quality deal flow. Regardless of where you are in the food chain, you don't want to be involved in deals that don't sell. And as you're hearing, I think, from a lot of folks today, most of the deals that come through on Title II platforms are rejected. For good or for bad, that's the reality. What has changed are two things. One is technology, and the other thing is regulatory structure, and those changes have been significant. We've got Title II, which basically opens up the use of general solicitation and private placements. 506 is a good thing. It's fairly easy to use. There's no mandatory disclosure. You can raise as much money as you want as long as you go to accredited investors. It's all good, and a lot of people say we don't really need anything else. Then we've got Title III regulation crowdfunding, not in effect yet. I'm predicting we will see final rules by the end of the year. Most people aren't really paying attention to it. I think it will be important for startups. VCs are starting to pay attention to non-equity crowdfunding. Why? Because that's where you get social proof and social validation. And those are things that get the attention of people with money. So I think equity crowdfunding will have a place for being the farm team for companies that are worthy of doing larger private placements. So I think it's worth paying attention, and there are folks in Congress who are looking to raise the limit from $1 million to $5 million. That's only a matter of time. So don't be too dismissive of it. It has its place. You've got to pick and choose. But today it's not available. Then we've got Title IV, Regulation A+. We'll speak mostly about Tier 2 because that's what's new. The old Tier 1 didn't work. It's been around since 1936 because of blue sky regulation. The limits have been bumped from $5 million to $20 million, but it's still going to have very limited use. I'd like to start off, but we've heard about Regulation A+. I'd like to just address some practical aspects of it, and I'd like to throw this out to the panel. I'm going to start with Doug first because he's probably the most, I use the word cynical, probably the wrong word, but I mean that in a good way. What companies do you think are good candidates for a Reg A+ offering?
So the reason that Sam phrases it that way is that he's been the Reg A+ guy, and I've been the Title III guy, along with Sara, for several years. So Reg A+ has an absolute specific applicability in the capital formation process from my point of view, as opposed to some of the other, like Title II could apply to any company that's looking to raise money. In order to do a Reg A+ deal, you have to have a level of sophistication, you have to have the resources to pay lawyers and accountants to audit figures and to market your deal. So to me, it's a great vehicle as an alternative to what we have always called a reverse merger with a shell. It's a direct public offering that an issuer can do. It's self-determinative if you don't want to work with a broker-dealer or an agent. So if you believe as an issuer that you have a broad audience for your product or service, you can raise money from your community, your affinity group, and you can do it effectively through a Reg A+ registration. So I think that people who feel that they have enough people who believe in what they're doing and what they're peddling, I think they can raise money through a Reg A+ offering rather than do a reverse merger with a simultaneous pipe. That's available as well, but I think that's its primary purpose. And the benefit is you're obviously going to the unaccredited crowd, and that opens up a whole new world of investors for these entrepreneurs or celebrities. That would be what I think is the best use case.
Okay, Peter, you want to?
Yeah, I'll just mention one. Some people who have non-traded REITs are thinking about using Reg A+. And non-traded REITs is one of the few areas where you have SEC registration, but you also have to file with all of the states. Not every state is a merit review state, but the states that are have rules about what REITs have to do, and not merely disclosure rules, but rules about very hard rules about the type of offering that you can do, what the sponsor has to do, what fees that you can take out of it. So what Reg A+ allows you to do is get state preemption for an offering up to $50 million. And as a result, people are exploring using it for REITs and non-traded REITs, and then hoping to reach a level of size after which they can then get listed on an exchange and never have to deal with the states.
Could I just ask a question on that specific point?
Yeah,
Since
please
Peter
do.
Seems
Please
it's a
do.
great use. Have you spoken to the staff and gotten comfortable that even though there's a specific business plan that's in mind, that they're not going to treat it as a blind pool offering, which is prohibited under the Reg A+? I agree with you. I think it's a great tool, and they've said that you can do it for Reg A+, on Reg A+. But I was concerned that maybe because of the undefined nature of it, it may be an issue.
Yeah, I haven't spoken to the staff about that. Other people in the firm have. I can't say.
Okay.
Yeah, I think there's only one way to find out is to ask the staff the question, because I'm sure they have a strong opinion on that. You want to chime in? Yeah.
Well, on the general
Yeah.
question of
Yeah, general
applicability
question.
of Reg A?
Well, just on what companies you think
Yeah,
are good candidates. If
I
I'm
mean-
a client, I come to you, what should I be to be a good Reg A+
Yeah.
candidate?
I mean, I'll echo some of the prior remarks, but my view is Reg A is really the closest analog to a traditional public offering, albeit at a reduced scale, a small scale. The Commission's view, I think, was to try and fill this gap, this chasm that exists between the public offerings that are getting done and the companies that feel like they could be candidates to be in the market and that 15 or 20 years ago were eligible candidates. And so, as the other commentators have said, it's a program that works where a company has their advisors together, has financial statements, and really believes that it can get that stock out and sell it to a broad audience. I don't think that it's limiting like some other mechanisms in terms of being only limited to a certain type of industry or thing like that. I mean, the shell company exceptions aside. So that's really, how I would look at it.
Okay, Sarah, I know you've got some thoughts.
Yeah, I think we're going to be surprised by who uses it, to be honest. And when you look at the things that the SEC said when they were adopting the rule, they were assuming that Tier 2 was not going to be used by startups. Well, I've got two that I'm working with who are absolutely full Glass Tuesday startups. And it is amazingly easy to get audits for Form Glass Tuesday startups. And these guys will be, in fact, actually there's a third company I'm working with, not yet formed. It will be formed sometime next week.
Before they file.
Yeah. Yes. Yeah. Well, actually, no. Otherwise, you couldn't do the opinion that you need that these things actually exist. But I think we're going to be surprised at the range. So non-traded REITs, I think we're going to see a lot of real estate. And I think we are going to see far more startups in Tier 1, possibly also Tier 2, than people expect. And I think we're also going to be surprised by some Tier 1 filings. Everyone's been saying, no, it's not going to work. Some people are going to try it.
Yeah, from my point of view, we're all going to learn from experience. I think we're going to be surprised. I think from a high level, the best candidate for Reg A Plus company is a company that's not ready yet for a national exchange listing, doesn't want to deal with Sarbanes-Oxley. It's a good stepping stone. And when you're ready to uplist and you meet the NASDAQ requirements or NYSE and you're ready to deal with everything that you have to deal with under Sarbanes-Oxley and be a fully reporting company, I think that's your best fit. And one of the big advantages of Reg A Plus is, yes, it's a registration process, not going to be any different than an S1, in my opinion, but once you're a reporting company, if you're a fully reporting company, as soon as that 10K is done, boom, you're already working on your first quarter Q. You've got your auditors coming out to review your financials. You're working on a proxy statement, okay? With Reg A Plus, there are no Qs. There's a semi-annual. Number two, there are no reviewed interim financials. So compared to a reporting company, that's going to save you at least $25,000 a quarter, plus management dealing with the auditors 4 times a year instead of 1 time a year. So these are significant advantages for a company, I think. On a lower level, yes, I'm hearing interest by REITs that are simply not interested in having a trading market. They're not interested in seeing their stock trade below net asset value, but they have unaccredited investors that they have access to, and if they have more money, they can do more deals and they can make money. So even though they have no interest in a secondary market, in fact, they don't want it. They want to restrict the shares. That's one use which wouldn't seem intuitive to us folks who want to take companies public and like to see them thrive as public companies. I think it's going to work best for companies that have a strong affinity group or network, whether it's their distributors that they want to put stock in the hands of, they're their customers. I mean, probably, one example, a colleague of mine went to present at a marijuana conference in Denver, and there's incredible interest in this area because why? You've got lots of stoners, as he put it, who want to throw $500 at the next marijuana company that's going to be. So you're going to see these kinds of things. If you have a star or celebrity associated with the company, rightly or wrongly, that's going to attract a lot of attention. That will attract investors. So I think we're going to be surprised at the range. We will see some startups. And remember, probably the industry that was most excited about Reg A Plus was biotech, companies that have no revenues. They have IP. And we will see startups. We're going to see a lot of them fall on their face, and people will learn the hard way, but we're going to see some of those. Yeah, sure.
The cannabis companies. There's one super geeky thing about Reg A, which is appealing to cannabis companies. If you're going to do an S1, The SEC, in order to let you go effective, has to make a determination that is in the public interest for it to go effective. Imagine what Congress does when the SEC sits there saying, yes, it's in the public interest that all of these companies raise money for all of their donors. That doesn't happen with Regulation A. Regulation A is a qualification process, and therefore the SEC does not have to make that determination. So it's kind of easier for them to do it and let those companies become effective without having to incur the ire of Congress.
Okay.
Kind of weird thing.
Right. My next question is for Doug. We have lots of pre-jobs methods of taking companies public without an underwriter. We have S1 direct public offerings. We've got reverse mergers. And we also have Form 10 shells. I know, Doug, you're more than familiar with that area. Typically, they don't involve broker-dealers. What is your thoughts about what you expect to see in terms of Reg A Plus offerings without broker-dealers selling the deal? Do you expect that that's something we'll see?
I think the other panels are making a good point. There's so many use cases that you don't necessarily, they're not readily evident. So whether or not it's the cannabis industry or otherwise, the REIT industry, that maybe there will be broker-dealers involved in the selling of some of these deals. We're not seeing that currently. It's do-it-yourself financing. They may get closed through TriPoint, who has their bank system, who I was up here earlier. So maybe there's a broker-dealer involvement in the process for the closing of the transaction. But for the most part, what we're seeing so far is that the entrepreneurs believe they're going to do it themselves.
Right. And what are you seeing or sensing out there in the world in terms of interest by investment bankers, broker-dealers in the Reg A Plus space?
We've received a few. There was a flurry of activity of inquiry, but at the end of the day, we don't have any that are involved.
Okay. Peter, let me ask you a question, a little more down in the weeds. We will have broker-dealers involved in Reg A Plus offerings. I think that's a good thing, given the size of the offerings. What issues do you see that broker-dealers need to be concerned with from let's say, a FINRA compliance point of view in the Reg A Plus process?
Well, assuming that these things are sold by brokers on either a best efforts or a firm commitment basis, many of the same rules that apply to them for public offerings are going to continue to apply. So they are going to have to do corporate finance filings under 5110, right? Because the FINRA rule 5110 specifically includes Reg A offerings as a type of offering that needs to be filed. Regulation M will apply. It'll be clearly a distribution under Regulation M. Surprisingly, when you look at Rule 5130, which is the new issue rule, what we used to call the hot issue rule, that appears to apply here. The definition of new issue looks like it will include these offerings. And it's similarly 5131, which is the rule about allocations of stock offerings, will also apply. The one that in the REIT space that people are concerned about, there is a new rule that FINRA has adopted, which becomes effective in April of 2016, and that rule has to do with account statements. Brokers are supposed to give account statements to their customers, and those account statements have to state what the value of the security is. In the REIT space, in non-traded REITs, for years they would just show this, they would sell the security at $10 and they would show it at $10 for a long time. But now FINRA wants you to be able to actually value the securities, and they give you a couple of methods that you can use to value it. That rule applies to what it says are REITs, which are publicly offered real estate investment trusts, and there's nothing in the definition that would exclude it. So people who are thinking about using it for REITs are concerned about the fact that they may have to, that brokers are going to have to follow the account statement rule when it becomes effective.
So let me just ask you something. One of the big features about Regulation A Plus that people like is testing the waters. Before you hire accountants and attorneys, you can go out and solicit non-binding indications of interest, and the SEC rules allow you to do that at any time up through the time that you're approved or qualified by the SEC. Now, FINRA has some very specific rules on advertising. Some of the folks that'll be out there testing the waters won't involve a FINRA registered broker-dealer. Others, some will and some won't. Tell me a little bit about the advertising rules and whether you see that kind of dampening or restricting the kind of advertising that a company could use in testing the waters if they're utilizing a FINRA broker-dealer.
Well, the FINRA Rule 2210 is the communications rule, and it applies to, they create different categories of communications, correspondence with just a few people, institutional communications, and then communications with retail customers. And retail is defined as basically people with less than 50 million in assets. And those rules have several different requirements, or that rule has several different requirements. One, there's requirements having to do with filing. This doesn't sound like it's going to be the kind of thing that has to be pre-filed with FINRA. And then there are content standards.
Right.
Content
That's
standards are a concern. Like anybody who works with, for instance, with hedge funds or other funds of that kind, know that there are standards that relate to using projections or forecasts. Basically, you're not supposed to do it. And similarly,
you can't. You cannot do it under the FINRA rule.
Right, you can't.
Yeah, it's
you can't do
prohibited.
it. That is to say that a broker may not distribute material that has those things. FINRA has said that if it's in an offering statement that's
But if the FINRA broker approves that material,
well,
then I think the rule speaks to that.
The
I'm
rule
not
says that
mistaken.
if the broker prepares it or distributes
approves it,
or approves it, right?
Yeah.
But FINRA has been saying in public meetings that if all they're doing is just handing out an offering statement that was created by the issuer, that might not necessarily be subject to the content standard.
But an offering statement is one thing. Testing the waters, solicitations. I'm going to just ask Doug to weigh in on that because I know Doug has a lot of expertise in the broker-dealer area, and I understand has a live deal
the
like
only
that.
current example that we have is that there is one deal out there where, in fact, it got roped into the ad regs group, and they wanted to review the materials, everything. And
Right.
I think there are the rules, and then when the rules are applied to a new innovative program, and those rules tend to expand.
Exactly.
I don't know how that is. Sarah probably can share a little bit more information on that point. But I'd be very solicitous of FINRA to make sure that everything you do is pre-cleared with them, or at least previewed with them, because they're paying close attention. They claim to want to be a good partner in this, and so far they have been. They have looked at the materials in the one deal that I'm aware of, and they've actually been productive.
Sarah, do you want to add anything to that? I think we covered it, but feel free.
No, I think in many cases, brokers are going to step into a deal after the issuer has already done whatever it's going to do, which gets into some really interesting questions with respect to projections, for example. So if you have an issuer who goes out with projections, and on its own, no FINRA member involved, and now they have the projections as part of the TTW, now those projections are going to have to be filed with the SEC as part of the TTW exhibit. I would expect that the SEC is going to have some conversations about you are going to have to take those projections, put them in the offering circular, and take responsibility for them. So don't be surprised if that happens.
It's certainly going to generate comments, and it could, comments with a view towards disclosure. I mean, we've seen that language, so I think that's a real possibility, and we'll kind of live and learn through the process. I just wanted to make the point, though, that, and this applies also to Title II, 506C, you can generally solicit, but there are very stringent FINRA rules about what you can say. They're much more strict than 10b-5. There are absolute prohibitions on certain things. So your hands, I think, are pretty much tied, good or bad, and Yeah, I'm not surprised that FINRA is going to look at all of these solicitations very closely in the beginning. One of the advantages of Reg A Plus is over Title II is you have liquid securities. But I've also seen people say things, and there's a lot of misinformation in the press. Well, but there's no secondary market for these securities. So Gerry, what I'd like you to address is tell me what you expect the secondary market to look like for Reg A Plus issuers who've actually successfully raised the money. What are their options
Sure.
in that context?
So let's start with the proposition, as you just said, Sam, that a Reg A Plus offering is much more akin to a registered public offering than it is a private placement. It's a qualification process that's similar to the SEC review process for an S1. And as a result, the securities that are issued and that are required by non-affiliates as a technical matter are unrestricted. But when you start there, then you really end up with, I think, a two-tiered analysis. Let's not use the word tiered. It's a bifurcated analysis, and that's based upon the fact that for a Tier 1 offering, you don't have the state preemption. So if you have securities issued in a Tier 1 offering, you have to think about state law, blue sky restrictions on resales of those securities. And so in the case of non-affiliates, you could presumably use the isolated non-issuer transaction exemption. You have to maybe look at that on a state-by-state basis. This also sort of harkens me back to the old 504 days when companies used to do offerings in reliance on 504 and then would seek what was called the manuals exemption. I think a Tier 1 issuer could use the manuals exemption as a way to try and facilitate potential aftermarket liquidity for shares that are offered in a Tier 1 offering.
The manuals exemption is simply an exemption that you get if you are published in a manual like Standard & Poor, and you provide information of a type that the state will sometimes specify it has to include at least the following information.
So that gets you into 32, 33 states, something like that. You compare that to a Tier 2 offering where you've got the state preemption. That makes it a whole lot easier on the aftermarket side, so you're not really dealing, because they're covered securities. I think the other advantage in the context of a Tier 2 offering is you've got some limited reporting obligations, these semi-annual and annual reports, and these limited current reports that would provide information from which investors in the aftermarket might be able to look to get to figure out what the securities are worth. And I think that's where, in a remark you made, Sarah, I think that there's going to be a surprise, and there's going to be a much higher percentage of companies that are going to use Tier 2 than people think. And they're going to do it because of the state preemption issues, as long as they can get the audit piece done. It gives them a lot of other benefits that they might not have thought come with the basket. So I think in terms of the resale landscape, Tier 2 is really going to be where people will be going. I also think that there's that other provision in Tier 2 where companies, if they really start to develop a decent market, and companies say, wow, there's that option to file the 8A without having to file a separate Form 10 for a Tier 2 offering, if the companies are willing to go the whole distance and subject themselves to full-blown 34 Act
In other words, if they're crazy.
Well, I'm just saying that some people may do that. I don't know.
Okay, but let me just ask you a question. I'm an issuer, and I say, okay, I have a public company. Where can these securities trade? I want my shareholders to be able to go on Yahoo Finance, punch in a symbol. Is that possible with Reg A Plus? How's that going to happen?
These are still going to be over-the-counter securities, and not unless they're listed on a national exchange.
Right.
Then these securities are going to be. I guess technically, I'm thinking they can be bulletin board OTCQX securities.
Right.
But in a practical world, there's not going to be much liquidity there because that's better than a 506 world where people are owning restricted securities. I mean, that's how you have to explain it to people.
Yeah.
This is not...
right. No, the point I want to get across is today we have markets that are amenable to Reg A Plus securities. I think we have Cromwell Colson, who's going to be speaking, the founder of OTC Markets. They have a 3-tier exchange, QX, QB, and the pink sheets. They have adjusted their listing standards to accommodate Reg A Plus offerings specifically for QB, which has all of a minimum of I think a penny bid, and it simply requires that you meet the ongoing reporting requirements of a Reg A Plus issuer. So that is an option, and for a lot of companies, you say, well, it's not NASDAQ. There are lots of companies on NASDAQ that are very thinly traded, paying very high maintenance fees to NASDAQ, paying a lot of money to their accountants and their lawyers to be fully reporting companies when they don't really belong there. I submit to you that for some companies, the OTC QB will be a good place to start. The trading may be very thin, and also keep in mind, we don't have time to get into this, there is legislation that's been introduced in Congress to create new venture exchanges, which would be a tier below national exchanges, which would have different trading rules and relief from Sarbanes-Oxley. That's the future. That's where things are going. That's got the support of 5 SEC commissioners, which is rare. It's already been discussed in the Senate and the House. That's going to happen. So if you're looking at long-term trends, Reg A Plus, the other piece of that is a secondary market, and there are better minds than mine that are already intensely focused on that. We've got pending legislation, so I think that's important. Sara, let's talk a little bit about marketing and advertising, and maybe I know you've done a couple of things. You've worked on huge bulge bracket offerings, and you've also worked at the SEC, so you have a lot of good perspectives. How are Reg A Plus offerings going to differ in your mind in terms of how they're marketed compared to the traditional IPO when the SEC says you can go effective, you close within 3 days, and you're done? Okay. How do you see these given the Reg A Plus rule?
I think one of the things that's going to be important is the fact that these are going to tend to be ongoing for a very long time. The old, we'd go on the road show, we sell, we circle up everything, then we close, and then we distribute. That's not necessarily going to work, at least at the lower ends. I think in the smaller offerings, what we're going to see is you get qualified by the SEC after you've done your TTW, and then you've taken down, and this is an important thing, you're going to have to take some of your TTW materials down from wherever you are using them, because once you're qualified, the only thing you can use is the offering circular. So at that point, after you've done some of your sales, you're now going to be continuously selling, because I don't think they're just going to wait, get the SEC to sign off at the point where you've sold 100%. You're only going to have sold some portion of it, so it's going to be an ongoing process.
Okay, but what if I want to use my testing the waters materials after it's qualified, but I deliver a prospectus to the investor?
That's not in the rules. The important thing here is every offer or sale of securities must be registered or exempt, and the only exemption that you have is Rule 254, which is for the use the offering circular, or 255, which is test the waters, and test the waters only goes up to qualification. So anything that you have been using beforehand, and this includes videos and things, unless you take the entirety of the video, stick it in the offering circular, and then get permission from the SEC to have the actual video, because we all know you can't file videos on Edgar. Unless you've done that, then the video's got to come down. And probably, I've got to call into the SEC on this exact topic, probably you're not going to be able to keep the video up anyway. So there's the point at which all of the sexy stuff that you can do, and I've seen amazing TTW stuff. I've seen characters in video games turn to say, are you enjoying playing this video game? If you do, you might want to invest in the video game production company, which is fine, so long as you have a link to the SEC required language. All of those sexy, innovative things that you can do right up to qualification, stop at qualification, and it gets super boring, because the only thing that you use to offer securities at that point is the offering circular. So if you've got sexy stuff, put it in the offering circular.
Yeah, and Sara and I are going to have an offline conversation about this, and we're going to get down into the weeds because it is pretty technical, but a lot of these offerings will be sold as crowd-funded offerings. They're not going to be sold by the time the offering is qualified. And I believe there's going to be both pressure and attention on what are very restrictive SEC rules to broaden that. And there actually are some safe harbors, but they won't help anyone because they don't apply to penny stocks and stocks that are on a national exchange. So it's my belief that the SEC simply has not focused on that area very much, but I predict that that's going to get a lot of focus in the next year or two, and I think we're going to see some expansion of that for these offerings. Let me.
We got a question about it.
A question. You're going to have to buy me lunch for that one. So, no, I want to get to one other question because I think it's important. I want to give everyone a chance to answer this here. People want to know, how long is this going to take and how much money is it going to cost? I'm going to start with Sara because I know she's more than well qualified to give opinions on that. So.
Well, how long it's going to take, I think we start off with, in the early days, it'll probably take longer to get through the SEC. But in my old life, we used to estimate maybe 90 days to go through the SEC. It will be shorter than that, at least at some point in the future after the SEC's gone through a few of them. So I'd be very surprised if it took longer than that. And as far as costs go, extraordinarily cheap if you use CrowdCheck.
That's why I had her answer first, because she's bringing efficiencies into the marketplace.
1/20th of what I used to cost.
Efficiencies with quality, which matters in this area. Gerry, you want to?
I would say from a timing perspective, I think 90 to 120 days is a reasonable estimate of the time. I also agree with Sara that the commission will get better at it, and I don't think that they have any vested interest in dragging it out. I think from a cost perspective, it has to cost less than registered offerings, and but it's going to cost more than a bare bones private placement. And where the interim or where the value proposition fits in the middle really depends upon how prepared companies are and really what the product is that they're looking to get.
Yeah, I agree with the prior comments. I just wanted to say one thing is that one way people will attempt to bring down the cost, and we've sort of discussed this, is instead of using brokers to use, I'm expecting that online platforms are going to enter the market.
Not BDs?
Well, the problem is that for the most part they do have to be registered as brokers.
Right, that's what I was trying to understand.
That's right, but they're they're going to sell their services in a way that's going to be less expensive than if you were to use an ordinary underwriter.
The only variation on that, because I think it's all correct, having worked on a lot of new programs, is I think the SEC is going to take a fair amount of time before it normalizes to the time frame that Sara was speaking about. But I also think there's going to be a considerable underestimation as to the time to get on file from the time the entrepreneur wants to start the process. They're less sophisticated, they don't have the infrastructure, and so that process, which ordinarily would take 30 to 60 days, I think may be longer, as well as, and we've all talked about it earlier, the filings that have been made already have been deficient in so many ways, they're getting bounced. So work with professionals who can actually have the respect of the staff, and like anyone up here, and will get your filing through the process. Because if you don't file a document with financials, you're not going to get any review. And then as it relates to the cost, it's kind of like, which do you want? Hot, cold. Sarah's less expensive than we are, and we're somewhere in between the other two. But it can't be done really inexpensively the way a Title II campaign can be done. So it will cost real money.
Okay, I think that's fair, but you forgot to put in a plug for
Sam Guzik.
No, for IBOT. Georgia Quinn, her presentation. How quickly we
I
forget.
disclose first of all.
I mean, that program is used and useful in Reg A Plus, correct?
It is not currently.
But it will be, and that will bring down the cost.
She's here. I'll let her answer that.
No. I mean, she reports to you.
It is something that we may do in the future. It is not currently on the drawing boards.
The bigger point is we've got technology that's really driving costs down, and we have attorneys who are actually qualified to handle registrations that are really interested in being involved in this space and are willing to not charge exorbitant rates to get it done. Okay, Steve, I'm going to take a question now. So do you need a microphone? Does he need a microphone? Okay.
You made the comment that those
Would be, would not be.
Well, at first it sounded
Well, for the-
like you don't need to keep the cost low because you're not going to carry typical underwriting type fees. And then it was almost like you capitulated and said, well, they'll be registered. And I'm just, I mean, as long as you're not taking compensation in conjunction with the offer and sale of securities, blah, 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 success fee, blah, blah, blah.
Can I address that?
Shouldn't you technically be able to, help with the distribution?
Sure, go ahead. I mean, we're going to see hybrids here. It's not black and white, but go ahead, yeah.
So the problem is that there's a spectrum people do, and at one end of the spectrum, they're clearly acting like brokers and receiving compensation. Merely because you don't receive compensation doesn't mean that you're a broker, and the SEC has said that. So while they focus on the type of compensation and the amount and that sort of thing, you don't get out of it just by not charging compensation. And so there is such a thing as just having a platform where all it is just a place like Facebook where people can say anything that they want. At that end, maybe you're not a broker, but once you start doing other things and there's not enough time to get into them, you really start to slip over the line of needing to register.
It's not the list. There are 5 factors, but let me tell you something. If you want to get a clear answer from the SEC, if you do, it's probably going to be an enforcement. So it's not going to. You'll get a clear answer. Yeah. I mean,
That's the heart of the issue because it would seem like Congress wants this kind of
right.
thing to develop. They
Well,
want it to be
we
easier tech solutions. So if you have to be a broker dealer, it kind of negates the whole idea.
Look, we had a provision that Congress put in Title II for 506 offerings, which basically says if you're posting, transactions online and that's all you're doing, then you don't have to register as a broker-dealer as long as you don't get transaction-related compensation.
You don't get any compensation.
Well, yeah, pretty much. So what the SEC did about 9 months later in a Q&A is they basically wiped that off the map. I mean, whatever Congress intended, wiped it off the map. The only thing they left that you could do is due diligence, and as an external service, I don't know how that got in the bill, but no. But the point is, there is not even that similar, what I loosely refer to as a safe harbor in Title IV. And one of the things I'm pushing Congress to do now, and it's going to be a long time, but eventually it will, is there won't be any relief from the SEC. We're going to need statutory change to recognize the new world that's developing. There are lots of service providers out there that are involved in the solicitation process, ancillary processes. They're not getting transaction-based compensation. And you mark my words, there will be legislation. It's going to take time. It's going to have huge opposition. We've got folks like FINRA and NASA and all the consumer groups. But it's going to happen. I mean, we have all these, as you know. You know what's going on out there. And you want to have somebody get a BD license that's not really in the business and have to deal with FINRA? Most of the smaller brokers I know wish they didn't have their license. I mean, and have to deal with FINRA because they don't just come and look. They ask you to write checks. So yeah, that's their budget. I mean, yeah.
The SEC, I'm curious if everybody would agree that the SEC
Well, in my opinion, and if I interpret Commissioner Gallagher's opinion correctly, they did exactly that in their Title III rulemaking, okay? And I won't cite to the source now, but this isn't written, it's on the SEC website, okay? I'm not going to say what they take a very hard line, a very strict view, maybe too strict in some people, but the relief has to come through statutory action, in my opinion, and it will. Yeah, I think we're done. Yeah. Okay. All right. Thank you, everyone. Thank you.